If you're charged with manufacturing, importing, exporting, or trafficking narcotics in federal court, this video is for you. We're going to close out 2025 with one of the biggest amendments to the federal sentencing guidelines, and it deals with drugs. Now, most individuals who are charged with narcotic offenses will look at significantly less time in federal prison because of these amendments. But before we go on, I want to thank you for watching me here on YouTube. If you're new to Lost Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.loststash.com and check out some of the merch. And if you've been paying attention to my channel, I've recently completed a 10-part series where I've discussed 10 of the most important criminal law decisions by the Supreme Court. And there I've mentioned that I have a promo code on my website. 10 cases. I believe it still works. So if you want, click in 10 cases, put that promo code on the website at shop.loststash.com and you'll receive 10% off. But now let's focus on the federal sentencing guidelines and talk about the amendments.
Quick message from Lost Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Stash YouTube page. That's LAWSTACHE.
If you've been watching my channel, you already know that I'm a criminal defense attorney based out of San Diego, but I take cases throughout California and Nevada. I handle both state and federal offenses. But this video is focusing on the federal law. We're going to be discussing the federal sentencing guidelines. As such, we're focusing on 2D1.1, which is the section in the federal sentencing guidelines that deals with manufacturing, importing, exporting, or trafficking narcotics. Also, if you've been paying attention to my channel, you know that I've discussed the sentencing guidelines many times. You should be aware that there's a table at the end of the book that's called the sentencing table. There are 6 criminal history categories on top and 43 offense levels on the left. The intersection of those is the amount of time you're facing in federal prison. That's going to be in months. How do we calculate the criminal history category? Well, it's based on your criminal history. And today, we're going to make an assumption that you do not have any criminal history and you'll be in category 1. Then the base offense level is based on the amount of narcotics, and there are some enhancements and reductions. And so, today, for the purposes of this video, to make it simpler, you're in category 1. The second assumption we're going to make is that you're safety valve eligible, which means either the mandatory minimum does not apply or you have been relieved from the mandatory minimum, meaning that the judge can sentence you to any time in federal custody. We're also going to assume that you've pled guilty to the offense, so you accept the responsibility and you will be receiving 3 levels off. Those are some of the assumptions we're going to make. Why are we doing this? Well, it's because in the Southern District of California, where I practice, most of the individuals are charged with importing narcotics from Mexico into the United States through the border. Most of the time, the individuals do not have any criminal history and they're safety valve eligible. The other assumption we're going to make today is that because we focus on the amount of narcotics, that's how we calculate the base offense level. Another word for it is the starting point. Well, we're going to assume that you're at level 38, which is the highest level under the guidelines. So if you look at the first column on the table that I've created, you'll be at base offense level 38. You will receive 2 levels off for safety valve, 3 levels off for acceptance responsibility. Because you have no criminal history, you will receive additional 2 levels off. Nothing for all for now. And then in our district, there's 4 levels off for fast track. If you go through the case a little bit quicker than usual, waive certain dates like indictment and preliminary hearing, you'll receive 4 levels off. This brings you to the total offense level of 27. You're in category 1, which means 70 to 87 months. Then let's talk about minor role. Minor role, or role adjustment in general, is found in Chapter 3. There's a 4-level reduction and a 2-level reduction. For years, judges would only give 2 levels off for what's called minor role. How would we figure out the role in the offense? Well, we would focus on how the defendant comprehended the scope and structure of criminal operation, how the defendant level of involvement in planning or organizing the criminal activity, the decision-making authority, meaning the extent to which the defendant exercised or influenced the decision-making authority, active participation, meaning the nature, extent, responsibility, and discretion involved in the defendant's actual criminal acts, and finally, the financial interest, the degree to which the defendant stood to benefit from the criminal activity. And on this last factor, what really we were focusing on is not that how much money the individual would make, not the flat fee, but rather would the individual be getting a flat fee or percentage off of profits. Of course, if somebody was getting a percentage off of profits, that means that individual was much more involved. So the federal judge would look at these 5 factors, balance them, and then figure out whether the individual would receive 2 levels off for what's called minor role. Here's what would happen if the individual would receive minor role reduction. Well, the base offense level, 38, would be reduced to 34. Now, under the older guidelines, the ones we had in 2024 and prior, in 2D1.1, it would say how much each level should be reduced. Again, for the purposes of this video, we're assuming you're at level 38. However, if you're at lower level, for example 36, I believe would be reduced to 33, and so on. Well, here we're assuming it's 38, thus the reduction becomes to level 34. You still get 2 levels off for safety valve, 3 levels off for accepting responsibility, 2 levels off for 0-point offender, and now you would receive the 2 levels off for what we now call minor role. And then of course, fast track still applies. You're at total offense level 21, 37 to 46 months. That is your guideline sentence. Again, the judge would not have to follow this recommendation. The guidelines are just that, they're a guide. The judge could still sentence you to lower or higher than what the guidelines say. Now, in 2025, there has been a significant change to the guidelines. The drug guideline 2D1.1 has been amended. And the most significant change is how we look at the base offense level if the individual gets minor role, and also minor role / minimal role. Under the new guidelines, there's now a cap on the base offense level. If the individual receives minor role, then the cap becomes 32. The base offense level cannot be higher. You still get all of the same reductions, which brings you the total offense level of 19, 30 to 37 months. So as you can tell, under the new guidelines, there's effectively additional 2 levels that are being reduced. I'm not going to go through all the numbers, but we're now in column 3 that's labeled minor role 2025. Now let's focus on the 4th column. This is minimal role. Under this adjustment, you will receive 4 levels off, and the base offense level is capped at 30. If you do the math, 30 minus 2 minus 3 minus 2 minus 4 minus 4, you're at total offense level of 15, 18 to 24 months. So focus on this table that I've created. Under the 2025 amendments, even at the highest level of narcotics, an individual who receives minor role adjustment will be at 30 to 37 months, and the individual who receives minimal role adjustment will be at 18 to 24 months. Now here's the interesting part. The guidelines of Chapter 3 were not amended, meaning that the judges still use the same 5 factors that I've previously discussed in determining the individual's role. However, if you look at Chapter 2D 1.1, which deals with narcotics, there is now an explanation to the judges what type of individual should receive the 2 levels or 4 levels off. You will see in the application of 3B 1.2 mitigating role to Chapter 2D 1.1 cases, the sentencing guidelines say that a 4-level adjustment under 3B 1.2a is generally warranted if the defendant's primary function in the offense was plainly among the lowest level of drug trafficking functions, such as serving as a courier, running errands, sending or receiving phone calls or messages, or acting as a lookout. Why is this important? In the Southern District of California, many individuals are charged with importing narcotics from Mexico into the United States, and thus they're couriers. And so individuals who are charged with importing narcotics through the border, by definition, are couriers and now should receive 4 levels off. Now, individuals who are also among the low-level trafficking functions should receive 2 levels off. So Chapter 3 now describes the type of roles that people play in the drug trafficking ventures and what individual should receive 2 or 4 levels off. There's also another important reduction that's not listed in the table, but it's worth mentioning here. If the defendant receives the 4-level reduction in 3B 1.2a and the offense involved all of the following factors. Number 1, the defendant was motivated by intimate or familial relationship or by threats or fear to commit the offense and otherwise unlikely to commit such an offense. B, the defendant received no monetary compensation from the illegal purchase, sale, transport, or storage of controlled substances. And C, the defendant had minimal knowledge of the scope and structure of the enterprise, decreased by 2. Which means that if you're already receiving the 4-level off under minimal participant, and these factors also apply, you should receive an additional 2 levels off. So if you're in column 4 of my table and those factors apply, then you should really be getting another 2 levels off. I hope this was somewhat helpful for you to understand how the federal sentencing guidelines work. Look again at the table, the 4 columns. In today's world, in 2025 and moving forward, you should really be focusing on the last 2 columns. Now, some people think that because the guidelines are explicit on some of these terms, that they can just walk in and get all the reductions. Well, that's not how it works. It is still important to hire the best lawyer that you can. It is your lawyer's job to argue to the judge that all of these reductions apply and get you the lowest sentence possible. That's the whole point of hiring a criminal defense lawyer. Now, I've also heard from some people that their lawyer does not write sentencing memorandums. Instead, they simply walk into court because they're so good at oral argument. Well, be careful. Judges make decisions on paper. Some judges, of course, can later change their mind in court, but it is important to put your best foot forward and try to convince the judge at every step possible. So focus on the sentencing memorandum, oral argument. Of course, bring any other mitigating evidence that you have, any character letters. By the way, I've previously discussed how to write the best character letter to influence the judge. All of those things should be filed on your behalf. Happy holidays. I hope you enjoyed this video. Thank you for watching my channel this year, and Happy New Year. If you're new to the Law Stash channel for whatever reason and this was your first video, of course maybe a weird one to jump on, but thank you for watching. Subscribe to the Law Stash channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com/merch and check out the Do Not Arrest This Person t-shirts, hats, stickers, and other items. Thanks for watching, and I'll see you next year.